The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to Council, and welcome to those who are watching us on our live stream today. I'd like to make a special call out. We have students from Pittsburgh who have read the briefs and are watching and monitoring this video call today. So we're excited to have that. I'd also mention we were a minute or two late starting because of some technical issues with the closed captioning. We will be trying to get that closed captioning moving as quickly as we can, but we will proceed at this time. So I would ask Mr. Doug Shima, the clerk of the appellate court, to please call the warning docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Thursday, February 4th, 2021 consists of one case. Appeal number 121467, State of Kansas versus Aaron David Cash, Johnson County, briefs both sides. The appellant has reserved 2 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Thank you, Madam Chief Justice. Brandon Bell, appearing for the appellant Aaron David Cash, present and ready for argument.
May it please the court, the State of Kansas plaintiff appellee appears by Assistant Johnson County District Attorney Kendall Kaut, present and ready for argument.
Thank you, counsel. Mr. Bell, you may begin with your argument.
Thank you, Madam Chief Justice, and may it please the court. This appeal arises from a traffic stop. Aaron David Cash was pulled over because the van he was driving did not have a registration sticker affixed to its license plate. When the officer began the traffic stop, Mr. Cash, who did not own the van, began looking for the insurance and registration paperwork that belonged to the van. While he was looking through that paperwork, the officer noticed a safe in the back of the van. The safe was partially opened, and the officer noticed a plastic bag and a Crown Royal bag hanging out of the partially opened safe. At that point, the officer began asking questions to Mr. Cash about the safe, which prompted Mr. Cash to stop looking for the insurance and registration paperwork and answer those questions. The officer then asked Mr. Cash to open the safe, which further required him to stop looking for the paperwork and open it. Once he opened it, the officer developed probable cause to believe that there was contraband in the vehicle, and the vehicle was searched. The question before the court is whether the questioning in order to open the safe unreasonably extended the scope and duration of the traffic stop. Ever since Terry versus Ohio was decided, there's been a two-step analysis for reasonable suspicion stops, which courts use to evaluate traffic stops. The first part of that is a subjective test, whether the officer has articulated specific facts that prompted the officer to subjectively be suspicious that there was criminal activity afoot. The second part of this test is the objective test, where the court looks at the facts that the officer has articulated and determines whether an objective or reasonable officer would find that those facts taken together would prompt that reasonable officer to suspect that criminal activity was going on. What happened in this case is that the officer only testified that she found one fact to be suspicious, and that fact was the presence of the Crown Royal bag. The officer never testified, and there was no other evidence that the plastic bag hanging outside the safe was a factor subjectively for the officer to find a reasonable suspicion. Despite the fact that the officer never testified that she found the plastic bag suspicious, the district court found that the presence of the Crown Royal bag and the plastic bag hanging out of the safe gave the officer reasonable suspicion. On appeal, Mr. Cash, in front of the Kansas Court of Appeals, pointed out that there was no substantial competent evidence for the district court to find that the officer had subjectively found the plastic bag to be suspicious. The state, in its briefing, did not point to anything in the record that would have given the district court a substantial basis to make that factual finding. The Court of Appeals opinion did not address the lack of substantial competent evidence or the officer's failure to testify that the plastic bag was suspicious. Instead, the Court of Appeals majority found that the Crown Royal bag and the plastic bag and the safe, the presence of the safe in the van, together gave the officer reasonable suspicion. Now, the officer had never testified that she found the safe subjectively suspicious. The district court had never found that the officer testified that, and the district court had never found that the safe, in combination with the other two factors, created objective reasonable suspicion, or would have prompted an objective officer to find reasonable suspicion. So in this case, the only substantial competent evidence that supports the officer's subjective finding of a suspicious fact was the presence of the Crown Royal bag. That's the only fact in the record that the officer testifies that she found suspicious and explains why. All of the other facts are those that either the district court or the appellate court found in the record, bereft of any explanation or evidence that the officer subjectively found them suspicious, but then the courts themselves found should be suspicious, that they should weigh them. That is not only contrary to Terry's founding premise and all the cases that follow, but also is a fact-finding step that the appellate courts should really not engage in, because it essentially widens the field for any fact in the record to become a suspicious fact, even if the officer never identifies it as a suspicious fact or a subjective reason to prolong the stop.
Counselor, let me ask you, you keep using the word subjective when referring to the officer's thought process, but I thought our test was simply to look at the facts and determine whether, an objectively reasonable officer would find a reason, reasonable suspicion to extend the stop. And so I want to make sure we're not talking past each other, that you're arguing one standard and I've got in my head a different standard.
Thank you, Justice Biles. I believe that the first step for the state to meet its burden, and this is from Terry, which this court reaffirmed when quoting in Jones, and also from the Supreme Court case in Socolow, is that the officer must be able to point to or articulate specific facts to justify the detention. So these are facts that the officer says, I saw X, Y, and Z, and those made me suspicious because. And those prompt the district court to say, all right, I have a substantial evidence and I'm making a factual finding that the officer found fact X, Y, and Z suspicious. And then we go to the second step of the test, which is facts X, Y, and Z would give the objectively reasonable officer reasonable suspicion that criminal activity was afoot. I don't think, with all due respect, Justice Biles, it is merely whether we look and say whether the officer, knowing everything the officer knew or maybe didn't know, and regardless of the officer's training and experience, and regardless of whether the officer thought a fact was suspicious or not, that the court functions as kind of a panopticon and looks at all the facts and just makes its own sort of determination. I don't think that would be consistent with, from Terry, what this court has said in the past regarding the Terry test and for traffic stops.
Mr. Bell, has this court ever addressed that issue front on? I mean, I know you cited to Socolow and some other cases, but is there a Kansas Supreme Court case that stands for that proposition that it's only the facts that are articulated by the officer that the court can use to determine whether a reasonably objective officer would conclude?
Thank you, Justice Standridge. I believe this court did address that issue in State versus Jones at 300 Can 630. In that case, there had been essentially 2 suppression hearings, and the officer testified at both hearings. The only one that was up on appeal was the second hearing. And at the second hearing, the officer didn't include facts that had been testified to at the first hearing, or didn't cite them as being suspicious. And this court said that while it won't look at a single answer and ignore the rest of the officer's testimony, that it's still, at some point, the officer has to point to a fact and say, I found this fact suspicious, in order for the court to evaluate.
So are you saying that, let's just, a hypothetical situation, the facts would show 1 through 6, whatever they are. But the officer, when the officer testifies, says, I was really drawn to items 1 and 2. You're saying that all of the analysis that follows after that has to ignore the other 4.
No, Justice Miles, I don't think that's accurate. I think that if the officer says, I was drawn to, or I found factors 1 through 6 suspicious, then I think the court looks at factors 1 through 6, even if the officer does explain further facts 2 and 3. Because at that point, the officer has complied with what this court said in Jones. The officer has given an indication, these are the facts 1 through 6 that I found suspicious. And then the court can evaluate those facts. But that's not what we have here, because the only fact that the officer identified as being suspicious was the presence of the Crown Royal bag.
Counsel, doesn't that standard, I'm sorry.
Go
Someone else.
ahead, Justice Stiegel.
I'm sorry. My question is just, it strikes me that applying that standard would at least have a tendency to undermine the sort of lodestar of these analyses, which is totality of the circumstances. So I guess I want to get your response to how do we preserve a totality of the circumstances analysis under your view of this case?
I think that the totality of the circumstances test serves as a sort of wide angle lens for the court so that the officer can't cherry pick certain facts, and then those are the only facts the court can look at, even if there are other facts that might have diluted or even negated a reasonable suspicion finding, right? So a court could look at, fact X, Y, and Z that the officer says these are what supported reasonable suspicion in my mind, but the totality of the circumstances test makes sure that the courts don't have to ignore facts A, B, and C, which might dilute the officer's reasonable suspicion belief.
Like your answer is totality of circumstances works to benefit the defendant, but it doesn't work to give reasonable suspicion.
Well, I think, I don't know if I would phrase it exactly that way, Justice Stiegel, but I think that's the gist of it. And the reason for that is that if it were the other way around, if the courts could look at the universe of facts to decide whether there was reasonable suspicion, regardless of whether the officer subjectively thought a fact was suspicious, well, now the court's become a fact finder. The court has decided whether it believes a certain fact was suspicious or not, which this court has repeatedly said we defer to the experience of trained law enforcement officers about whether a circumstance is suspicious or not. Because what happens in, hypothetically, an officer says, yes, I consider that, but I didn't think it was suspicious. But an appellate court later thinks that it should have been suspicious. And then maybe it should take it into it opens a can of worms that I think is particularly unsuited for the appellate courts.
So are you telling us that we have to pretend that the plastic bag and the safe didn't exist? We have to decide this case only on whether the Crown Royal bag is enough to trip reasonable suspicion.
I think that's right, because the test under the Terry stop procedure is whether the facts articulated by the officer that the officer found suspicious equate to reasonable suspicion. I do not think that Again, the court has to pretend that they simply don't exist, but I think that the court has to attribute no suspicion to them because the officer subjectively didn't attribute any suspicion to them under the facts of this case.
Well, what if the officer attributes something is suspicious? You know, let's just say driving in the neighborhood. Driving in this neighborhood is suspicious if you're doing that. Are we supposed to give credence to the officer's subjective belief that it's suspicion, or are we allowed to disregard kind of such a stupid thing to say, really, in favor of, I mean, it seems like we're creating an alternate universe here.
Well, Justice Miles, I think that that's where the objective part of the Terry test comes in, where the court looks at whether the officer's cited reason for suspicion is objectively reasonable, would be reasonable to an objective officer based on common sense and experience. And so I think when if the court is presented with a basis for suspicion that it finds fantastical, for lack of a better term, I think that's, again, is where the second part of the Terry test comes in, the objective reasonableness part.
Counsel, my last question at least. It strikes me that if we adopt the rule you're advocating for, we're going to create what we sometimes think of as a magic words scenario, where every officer in every suppression hearing will just testify, well, the totality of the circumstances made me suspicious. Isn't that what's going to happen if we adopt your rule?
I would hope not, Justice Stiegel, because I don't think that that would satisfy this court's or the Supreme Court's jurisprudence either. And I want to be clear, I'm not asking the court to adopt a specific rule. I'm just asking the court to follow the opinions that it's already set down for these circumstances. But I think that if an officer were just to say the totality of the circumstances are what made me suspicious, I don't think that would meet the Terry standard, which requires the officer to articulate specific facts, not just a general broad brush, but specific facts that prompted that suspicion.
Mr. Bell, what do we do with the affidavit in this matter? Indicated that the officer saw track marks on the driver's arm, but she never testified to that at the hearing. Is that something that can be considered?
I don't believe so, given the posture of the case, Justice Standridge. That was not one of the factors that the district court considered, and it made its ruling, and it's not anything that the state has argued on appeal since.
What if, counsel, the person was leaving a drug house, but the officer didn't know it was a drug house? But the evidence came in that it was a drug house during the course of the hearing. That's something that commonly is used. Would the court be able to consider that under the totality of the circumstances?
I wouldn't think so, Justice Wilson, simply because of the first part of the Terry test, which requires the officer to articulate suspicious facts that was known to the officer that prompted it, or prompted the stop, the detention. I think that that's a good rule, and the reason for it is that if it were otherwise, officers would have an incentive to essentially roll the dice, while they not be able to point to something that they believe is suspicious at the time they want to detain somebody. Maybe there's some fact or set of facts out there unknown to them at the time that will later justify their action, which is not the behavior that court in Terry or the court since have wanted to encourage. It's not the incentive structure that the courts have wanted to create surrounding the Fourth Amendment.
Mr. Bell, what weight do we assign to the training and experience testimony provided by the officer as bolstering whatever she articulated as reasonable suspicion?
Thank you, Justice Wall. And that was something that was pointed out by Judge Buser in his dissent. In Moore, this court gave substantial deference to a trooper who had a wealth of experience in interdiction and actually trained other law enforcement officers. So the court said in certain circumstances, when there is an officer who has this degree of training, that can sort of push the objective test and give deference to that level of experience. Here, the officer had been a patrol officer for roughly 4.5 years. Her training in drugs amounted to the training every officer gets at the police academy. There was no evidence that the officer had undergone any sort of specialized drug training or anything like that. So I don't know if the court is going to want to grapple with that issue in this case, but it certainly seems like, and more if a lot of experience would sort of push further towards the objective test, a relative lack of experience might have a opposite effect on the objective test. But I think the easier answer to your question is, Justice Wall, is that it shouldn't play any part in the court's decision because there simply is not the breadth and depth of experience this court has previously cited as having an impact on its decision.
Go ahead.
Go ahead, Chief.
Can I focus a little bit just on the language of Jones, since you rely so heavily on it? The court there says that we will examine only the evidence presented to the district court judge, and that the state has the obligation before the district court by presenting testimony. And then that goes on to say, we look at the record to see what the district judge was asked to consider from the transcript of that hearing. At least as I'm looking at the language used that I've just summarized there at page 643, it doesn't limit that to what the officer said was the most suspicious. It's what was the evidence that was admitted. What were this, again, back to the totality of the circumstances and what was that evidence. The difference was that here, there were things that only an officer could describe, like the eyes were, in Jones, the eyes were bloodshot. That's not something that an appellate or even a district court judge could know without a description from the witness. But a safe or a plastic bag is something that doesn't require that kind of description from the officer. So can you point me to exactly why you think the Jones holding with that language focuses only on what the officer articulates as the grounds for that officer's suspicion?
Yes, thank you, Justice Bucker. So on page 644 of State versus Jones, this court quoted Terry to state that the police officer must be able to point to specific and articulable facts, which, taken together with rational inferences from those facts, reasonably warrant the intrusion. That's unquote. The court in Jones also quoted United States versus Socolow to say that a court sitting to determine the existence of reasonable suspicion must require the agent to articulate the factors leading to that conclusion. So here it's the fact that the officer, I think those cases and this court citing of them favorably or quoting favorably of them Jones shows that the officer still has to identify the fact as something that subjectively prompted the officer to be suspicious. Because, and I understand that, Justice Luckert, the sort of dichotomy between facts that might be innocent without the officer explaining why they're not, versus facts that would strike us or strike the court as lay people as inherently suspicious. I think that presents a particular problem because where the line gets drawn between the court substituting or using its own subjective belief that something is suspicious versus the officer deciding and in the field that something struck them as suspicious. I don't know that it should be, or that the appellate court necessarily wants to be making its own determinations about whether a fact is suspicious or not in the first instance, without the officer saying, I saw this and I found it suspicious because it gets difficult, if not impossible, to draw the line at where the court can, what facts the court can and cannot call suspicious in the first instance without an officer ever saying that they found it suspicious.
Justice Rosen.
I see my time has expired. Unless anyone has any questions. Thank you.
No, thank you, Chief. I can follow up on rebuttal if I need to.
Thank you. Any other questions? Okay, thank you, Mr. Bell. Mr. Cobb?
Thank you, and may it please the court. This case comes down to two factors. The first is that reasonable suspicion is a very low bar for the state to clear. And the second one are the 3 or 4 facts this court has to consider for whether Officer Demarest had reasonable suspicion to ask one question about drugs as she approached the car and saw those items in plain view. I think it's probably fitting to start with the plastic bag since that's where most of the questioning was. I think this court can avoid even having a discussion about how much do we read into the record or what's necessary to read into the record, because the actual transcript, I believe, supports that Officer Demarest believed that the baggie was drug paraphernalia. On page 54, and part of her answer, she says, I observed it, and it references the safe, partially open, and what I believe to be drug paraphernalia partially outside of the safe. Later on page 54, the question is, what did you see inside that safe? I saw a small purple felt bag. We know that's the Crown Royal bag. And then a small bag, plastic baggie. To me, reading those two parts in conjunction implies to me that Officer Demarest believed that a baggie was drug paraphernalia. And I'd hoped to not have 2 days in a row of the lights going off, arguing in front of you all, but maybe that'll be a record like Ted Williams' 56-game hit streak that no one else will have back-to-back lights off days in front of you all. But I believe that is sufficient to say this officer believed that was drug paraphernalia. I also believe that quoting part of Jones, as the Chief Justice did, and as other justices have done, is correct here. Another part of Jones on page 645 of that opinion, mid-paragraph says, all facts and inferences, not a select few, must be considered. Therefore, we should not focus on a single answer and overlook an officer's omission of a factor when asked to list the basis for a reasonable suspicion if at some point in the officer's testimony, he or she indicated the circumstance was a factor in developing a suspicion of illegal activity. Here, I believe that is enough to at least trigger that being a part of the reasonable suspicion analysis. Now, this court may elect that that is not a sufficient factor, but I believe it is at least a factor to consider.
Mr. Cout, let me ask you this. At what point did the officer have probable cause to search the vehicle?
Justice Stanridge, I believe the probable cause develops after the questions asked about the safe, and then he mentions that there would be a pipe in the safe. So I think the probable cause comes then. I do think there is a gap between just seeing those items and then searching the car. So I think there was something else there. So I think this hits reasonable suspicion, but I don't know that it hits probable cause. So I think at least that was necessary. So we are at a very close level here.
So what authority, if she didn't have probable cause, did the officer have to direct the defendant in this case to open the safe? Because it seems like that's a search. And if you're directing someone to open a safe, it'd be like directing them to open luggage or their backpack or, something that is, in there. But was there probable cause to direct him to open the safe?
So Justice Stanridge, given that issue was not briefed fully, I don't want to misstate any facts or misdirect the court in any way about stating that area of the law, but I do agree that that's an interesting question given the facts presented. So I certainly want to make sure I answer your question directly. I believe had that been briefed fully, our argument probably would have either been that this was consent because of the tone of the officer. In fact, the majority panel in this decision mentioned that the state could have argued consent potentially, but chose not to, or the state might have argued this was an investigatory detention and that question was still investigatory in nature and not quite enough to trigger that. Now, maybe that's a bridge too far, and that might be a reason why they should have briefed that issue. But given it wasn't briefed, I think that would have been the land we had gone to had it been relevant. I think it might have been a relevant issue to have brought up to not trip me up if there's ever a future motion for ineffective assistance of counsel. I think all counsel's been very effective so far, but I think that would probably have been where we would have gone with those arguments.
Thank you.
I have actually the question I had for opposing counsel also is kind of the same for you. And it follows Justice Wall's observation about legal training or experience of the law enforcement officer. Here, there's 4.5 years. It's not exactly like this officer's a rookie, but maybe isn't comparable to some of the cases where we've had drug training with officers and education like that. How does that factor in here where the officer testifies 4.5 years experience? In her experience, drugs are contained in baggies, specifically Crown Royal bags. How does that play into the reasonable suspicion? Is that enough if you see a Crown Royal bag and based on that experience, that is reasonable suspicion, or does it take more?
Justice Rosen, I think it is a close call there and it might take more. I think to kind of unpack that, the issue I might take, with all due respect to Judge Buser, when he talks about how the case that he cites in his dissent mentions that the KHP trooper had like 17 years of experience, is I don't think that is a necessary component. I think that was the court in that decision articulating 17 years is a lot of experience. And as Justice Rosen, you mentioned, 4.5 years isn't quite as much. I don't think any of the cases, though, stand for the proposition that there is a certain threshold of experience necessary to then say we will automatically give more deference or less deference. To me, in this particular context, to directly answer your question, I think a Crown Royal bag with someone with 4.5 years of experience, this court could find is sufficient because this officer has asked about it multiple times, where she says, in my experience, multiple times, I've seen drug paraphernalia contained within a Crown Royal bag. The prosecutor asks, normally it doesn't contain Crown Royal bottles. She says no. I do recognize, however, there is a panel decision of the Court of Appeals that says that a Crown Royal bottle alone is not sufficient. If this court did choose to follow that line of thought, then Justice Rosen, certainly the answer would be no, adopting that side of the argument. To me, all of that comes back to reasonable suspicion often exists in sort of some shades of gray because the standard set up by the US Supreme Court in Terry versus Ohio does not give us kind of the neat yes, no factors. We do have an argument in this case about whether the clear plastic baggie is identified as paraphernalia sufficiently, but really this case comes down to, we can all agree there was a Crown Royal baggie, that an officer says a Crown Royal baggie often contains paraphernalia. There's a safe, that this officer now has a little bit more than 4.5 years of experience, and that there was a plastic baggie in a safe. And ultimately, once all those facts exist, it comes down to a judgment call about just, is that reasonable suspicion or not? And there are some panels that certainly say things like a Crown Royal bag can't be considered because sometimes they contain innocent matters. There are cases certainly that say that clear plastic baggies may not be enough. One differential that I think is important in this case, though, about the clear plastic baggie that does kind of harm Mr. Cash in this case, is that the officer testifies that the clear plastic baggie was not all the way visible. So for Officer Demarest, when she's trying to formulate exactly what's going on as she approaches this vehicle, she can't quite see what this plastic baggie is. And Jones, and in some of the other cases, what's important is that that plastic baggie is clear. So you understand immediately, if you're an officer, there are no drugs in this bag. It has an innocent explanation immediately. In this case, this officer can have that same innocent explanation, which might justify the reasonable suspicion to continue investigating this crime. Another, I think, issue that might come into play is, does the safe get considered or does the safe not get considered? Well, the state would still maintain that there is reasonable suspicion absent that safe. The safe is a factor that is testified to by the officer and is evidence this court can consider. That does get this court deeper into the weeds about what exactly can be considered, what's the bright line between de novo review for a legal conclusion, and is there substantial competent evidence that this officer believed that? That does get messier. But the safe at least matters in one respect, that it makes it so the clear plastic baggie is not immediately visible, as I've mentioned. And the second one is that Jones decision talks about how if you were someone who had drug paraphernalia or was distributing drugs, you might be more likely if you had a clear plastic baggie to try and hide that. In fact, I think it's page 648, they say that an empty plastic baggie does not significantly add to the suspicion. Common sense suggests that if the bag had been used to package illegal substances, Jones or his companions would have hidden the bag along with its contents. Well, this bag is partially hidden in this case because it's partially in a safe that is in a back seat that doesn't even have seats fully across the back of this vehicle. So I think that is different than the clear plastic baggie there, and at least provides a little bit more for this officer to have asked one question about what else is going on in the car and have some reasonable suspicion that this is a little bit different than some of the other stops. I do think that when this all kind of comes,
since you're kind of at a, let me just ask you, what is your position on defense counsel's, opposing counsel's position that you can't consider it just as a general rule of law, that Terry stands for the proposition that if there, it requires the officer to articulate specific facts to support reasonable suspicion. And in this case, the articulable facts were really the Crown Royal bag. I mean, do you also, I know in this case, you're arguing that there are other things that can be taken into account. Well, actually, right. What you're saying is that it was partially, the clear baggie was partially hidden and that there was a safe, and those things can be taken into account. But under opposing counsel's suggestion is that because that was not relied on articulated by the officer in this case, that's not one of the things that's considered.
Sure. So Justice Stanridge, I think that this also gets kind of messy. It's interesting when I mentioned that it kind of comes down to we can agree to the facts and then get to there. So want to directly answer the question, but this one might require a little bit more of me. So certainly if I haven't answered it sufficiently, please let me know to articulate my position. My view on this question is that if an officer, let's say, has a body cam, goes up to a vehicle and the body cam reveals a bunch of cocaine on a seat, but the officer never sees the cocaine herself, then obviously the officer would not be able to say, I had the cocaine as part of my reasonable suspicion, even if the body cam at, let's say, the court hearing would reveal that cocaine was on the seat, because that wouldn't be a fact the officer used to determine reasonable suspicion. Here, when I mentioned kind of the shades of gray, I think it comes into play with that safe. The officer does not explicitly say, the safe was a factor I use under Terry versus Ohio and other 1960s US Supreme Court law to figure out reasonable suspicion was triggered in this case. But I think that kind of the concern that Justice Stegall mentions is sort of what backs up the state's argument that what's going to end up happening if this court does say that each fact testified to by the officer must then be kind of pigeonholed or couched in the language of reasonable suspicion. It's just that the officer will then give every answer to say, I had reasonable suspicion here when I saw the safe. I had reasonable suspicion here when I saw this item. I think the standard based on that Jones language I had mentioned earlier is that the officer must testify that they observed or had those facts. And then from there, a court looks at whether those facts did indeed provide reasonable suspicion. I do think, though, that a defense counsel on cross-examination could pinpoint those facts and go through them and ask the officer particularly, did this factor play into your reasonable suspicion calculus? And because a trained officer is given some deference, it would cut both ways. We give the officer credit when they say something matters. And if a trained officer says something doesn't matter, we would also give that credit. So in this case, if the defense counsel had asked Officer Demarest, let's talk about the safe. And a defense counsel might say, safes could have money, they could have guns. You didn't see those, but they could have been in there in the past. Maybe he sold some items recently. Did you consider that? And if Officer Demarest had said no, then that would weigh in favor of the safe not mattering. And if the judge found Officer Demarest credible, as it appears that Judge Winnell did in this case, then I think that would factor in. But in a case like this, we're agreed there is not that explicit statement that here is why the safe mattered to me. Here's why that really mattered. And so that's exactly why I get where you're coming from, Justice Stanridge, that it's kind of in that gap there where we know this is a fact. We know the panel majority relied upon that fact, but the fact is not explicitly tied in. So is it too much for the court to then make that inference itself? Or is it appropriate for the court, like that majority panel did, to make the inference? I believe it is appropriate, kind of when looking back at least at the standard of review for a motion to suppress. We know that fact is supported by substantial competent evidence and has not been challenged, that those items were kind of hanging out loosely inside and outside at the same time. And that it then, I think, becomes a sufficient fact for a later reviewing court to consider and say, this officer observed all those things in a very quick second. And when that officer Demarest observed all those things, those can then factor into that de novo review of the totality of the circumstances. And this court can say it may not be a heck of a lot to trigger probable cause, but is at least sufficient given the very low burden of reasonable suspicion.
Thank you. That answered my question.
Thank you, Justice Standridge. If there are no additional questions, I'm nearly out of time. So I would just ask this court to affirm the ruling of the Court of Appeals that affirmed that the motion to suppress was improper.
Any other questions? Thank you, counsel. Mr. Bell?
Thank you, Madam Chief Justice. I'd like to start with the last part of the state's argument, where the rule it seems to suggest is that the officer can simply list the facts that occurred during an encounter without stating whether the officer found a particular fact suspicious or not, and then essentially throw it to the court or the counsel to make arguments about which facts should and should not be considered suspicious. I think that actually brings the scenario, or a close scenario to what Justice Stiegel mentioned, closer to fruition. Because while the officer won't just say totality of the circumstances, the officer will instead just list all of the facts that occurred during a particular encounter and then leave it up to others to argue what is suspicious and what's not. Apart from being bad for judicial economy, it would also contravene Terry and Sokolow, which all repeatedly say, and this court has said, the test, the first part of the test, requires the officer to articulate the specific facts that made them suspicious. And what this court said in Jones on page 645, which the state cited.
Counsel, I'm going to interrupt you real quickly. I'm sorry for that. Because I'm still struggling with this tension that we have where courts say the test is the totality of the circumstances, but somehow officers aren't allowed to just recite the facts of the stop, let's say, and then just say, hey, it was everything all together that gave me reasonable suspicion. It wasn't any one particular thing. It was the totality of everything. It just seems to me like that's the legal test. And why couldn't an officer testify to that?
Well, I think that would violate the rule that it can't be an unparticularized hunch or suspicion, because the officer still needs to be able to articulate or list what everything was, right? Fact 1, fact 2, fact 3, nervousness, bloodshot eyes, erratic driving. Right? This is not a difficult thing for trained officers to do when they see them. And there's no, whether it's 5 or 10 or 15 facts, as long as the officer found them to be suspicious and prompted their reasons for detention, the court can look at them, and it doesn't have to look at them separately. It combines them all together. And it can say, this fact by itself might not work, and this fact by itself might not be enough. But we combine all of them together, and then we find reasonable suspicion. And I think that's really one of what the totality of the circumstances test means. It means that courts don't look at those factors identified by the officer in isolation, but it looks at all those circumstances together to determine whether the officer's subjective belief was objectively reasonable. And again, I think that the test, again, at Jones at page 645, restates this. It says that at some point in the officer's testimony, they have to indicate that a particular circumstance was a factor in developing suspicion of illegal activity.
And I guess that's my point. Didn't that happen here? Based upon this officer's training and experience, 4.5 years, she testified to the relationship of the Crown Royal bag and other items containing drugs. Why isn't that what occurred here?
The only thing the officer testified to about being suspicious was the Crown Royal bag. So I believe that fulfilled the subjective part of the test. The officer has testified subjectively, based on my experience, more often than not, or multiple times, I've seen paraphernalia in these crown royal bags. Now, the court isn't given the type of detail necessary to burnish that statement because we don't know how many multiple means. When the officer says more often than not, we don't know if that means 2 out of the 3 times she's found one or not. But I think that can fulfill the subjective part of the test based on the officer's statement, and the court can make a factual finding. The officer subjectively found the crown royal bag to be suspicious. I think where that falls down is where we put the objective layer over it, whether as a matter of common sense and experience, we would give credit to that officer's determination that a crown royal bag in that circumstance would be reasonable evidence of criminal activity. Now, in some cases, like in Moore, where you have a trooper that has a lot of experience in drug interdiction, the court can note that experience and say, this is a close case, but we give a lot of credit to this trooper who has a lot of experience. And so that's going to inform our objective basis of the test. But that's simply not what the court has in front of it in this case. All right, I see that my time has expired unless there are any other questions.
Any questions?
Thank you.
Thank you to both counsel for your arguments this morning. We will take this appeal under advisement. Court is now in recess.